Good afternoon, everyone. My name is Diana Latanzio, and I'm a partner here at Russo Law Group. I will be your presenter for today's important seminar, The Key Steps to Special Needs Planning Success. Before we get started, I just want to go over some housekeeping items. All of the attendees are automatically muted. Please send us your questions in the question and answer box. You can message each other in the chat box. A link to the recording will be emailed to you, and please don't forget to complete your survey at the end of the presentation. For those of you who don't know me, again, my name is Diana Latanzio, and I'm a partner here at Russo Law Group. I'm the lead planning attorney in our Garden City location, and I have 25 years experience in the areas of special needs planning, elder law, Medicaid, estate planning, which means I have 25 or more to go. My bar memberships include New York State Bar, and I am also admitted to practice in the state of New Jersey. So enough about me. Without further ado, we're going to get started on this important topic of special needs planning. So today we will cover creating a financial and legal plan for your loved one's needs, the role of special needs trusts in protecting and preserving government benefits, the key differences between third-party and first-party trusts, and preparing for future care and ensuring long-term security. So supplemental and special needs trusts, there's a lot of confusion with regard to these types of trusts and the actual title in the name. So supplemental and special needs are two terms that can be used interchangeably. From a practical perspective, in our practice, we choose to use the word supplemental when we refer to third-party trusts and special needs when we refer to a first-party trust that we'll dive into in a minute. The benefit of using these types of trusts, and we use an acronym, so you'll often hear like SNIT or SNT, and it's just an abbreviation for these types of trusts. But the main reason for using these trusts is to maximize government benefits for special needs and to protect and preserve the assets that are in the trusts for certain government benefits, such as Medicaid and supplemental security income, so that the principal or the assets in these trusts cannot be counted as a resource to disqualify the person from applying for these special services and benefits. So again, there are two different types of trusts. There's a third party and a first party. The third party trust can be revocable or irrevocable. The first party trust must be irrevocable. And either of these trusts can be funded with different assets. It can be funded with real estate, a house, whether it's in this state or in any other state. It can be funded with liquid assets. So that would refer to like a bank account or anything that you can convert to cash, life insurance policies, and also retirement assets. Third-party trusts, again, we refer to them as supplemental needs trusts, can be established by anyone for the benefit of a person that has special needs. And the person with special needs can be any age, either under 65 or over 65. So these types of trusts are funded solely with the assets of the third party. So that would be, oftentimes I use this for parents or grandparents who are planning for a person that has special needs, is disabled, and may be collecting government benefits. So instead of giving them an inheritance directly, which may compromise their eligibility, we create this type of a third-party trust. And then we use the assets for that purpose. The beauty of this type of a trust is that there is no payback to Medicaid, there's no payback to New York State when that special needs person ultimately passes away. And the person that creates the trust, which we refer to as the settlor, can control what happens when the disabled beneficiary passes away. And can leave a legacy then to the disabled beneficiary's descendants or the siblings of the disabled beneficiary or charities, so that the person who creates the trust, the settlor, is completely in charge. Then we have a first party trust, which is often referred to as a special needs trust. So that's vastly different from the third party trust. The reason being is that this first party trust can only be established by the disabled individual. And this is a newer rule, actually, that the disabled individual, him or herself, can actually create this trust if that person has capacity. So in past years, there would always be an assumption that if someone is disabled, that they don't have the capacity to create their own trust. And obviously that's wrong. And so there has been a change and an update in the law to address that issue. So if the special needs person has capacity, he or she can actually create their own trust, which gives them, that freedom and independence that we want. If the person lacks capacity, then there's a carve around. So a parent of that disabled person, a grandparent, a legal guardian, or a court can authorize the creation of this type of a trust. This trust must be solely used for the benefit of the disabled person. And then here's where the age restriction comes in. The beneficiary must be under the age of 65, which again is different from a third party trust. So this type of a trust is funded with the beneficiary's own assets. So I often meet with clients with regard to creating this type of a trust if they have either been involved in some type of a lawsuit, like a personal injury, where they're receiving a settlement, a dollar amount, or if someone else didn't do proper planning and left them a direct inheritance. So if a third party trust was not established, and so this person was named as a direct beneficiary, and now they're receiving a lump sum of money that may compromise their eligibility for the governments that he or she is currently receiving, because most of the government benefits are means tested and have some type of a limitation, and we'll get to that in a minute. So that's the primary source of using, this type of a trust, and it does protect the assets and the income of the person that's receiving the benefit. However, if the assets in this trust are not exhausted during the lifetime of the beneficiary, there is a mandatory payback provision upon the death of this beneficiary to New York State. So New York State will recoup and keep track of all of the benefits the beneficiary is receiving. And then if there's any money left when he or she passes away, Medicaid will grab that, or New York State will grab that as an automatic repayment. And this type of a trust must be irrevocable. There is another option when we're planning for disabled persons who are receiving government benefits and are over the age of 65. So if that person cannot create a first party trust because of the age restriction, there is an option with pooled trusts. So this is an alternate to using a first party trust. And there are about 22 charities that are licensed in New York to create these types of trusts. The Teresa Foundation is one that we use often. And this is, again, a workaround with the 65 age restriction, and it allows the disabled person, to put assets into this type of a trust. And instead of the remainder going to repay New York State, you can at least support a charity. And so the remainder would go to the charity instead of being paid to New York State, which is a great option to have. Now, in creating a trust, one of the most important decisions is going to be, well, who's going to be the trustee? Who is going to manage this trust? Who's going to make important decisions for the disabled beneficiary? And so some options are, family members, friends, professionals. You can name a corporate trustee, which would be a trust, or a bank, a financial institution, or a lot of the pooled trust companies have trustee services as well. And so when making this important decision, you need to make sure that the person that you choose as the trustee is fully versed in knowing what the distributions that are permissible and the distributions that are not permissible, because you don't want the trustee to make a mistake when you've put together this great plan and again compromise, the disabled beneficiary's benefits. So it is an important decision, and you want to choose someone, that's a little savvy in the industry, and that can either work with a professional or can be well versed in knowing the government benefits, identifying the government benefits that the beneficiary is on, and making sure that any distributions are made correctly. Okay. So what type of government benefits may this disabled beneficiary or special needs person collect? It's very important to know when we're establishing these trusts. So the most common is SSI, Supplemental Security Income. There's also Social Security Disability Insurance, which is different from SSI. SSI is usually a program where a special needs person will receive a monthly stipend because he or she is unable to be gainfully employed and does not qualify for SSDI, which is different. SSDI comes from an insurance fund when the person has worked enough quarters and contributed to the Social Security system and would qualify for that benefit. And then there's also medical coverage, right? So we need a monthly flow of income, and then we need some type of medical insurance. And so Medicare and Medicaid are the two primary government healthcare insurance companies. SSI and Medicaid are two benefits that are linked. So SSI does have a financially means test, which means that a recipient on SSI cannot have more than $2,000 in resources or assets, money in the bank. So if he or she does, by virtue of a personal injury award, or again, a direct gift, an inheritance, that will disqualify them. And because the SSI and the Medicaid, in terms of the health insurance, are linked, it will also cause an issue and could be a delay in services or, doctor visits. And so we want to make sure that that person's life is not interrupted in any way and that everything is, a smooth transition. We would love for them to, receive this extra pot of money, but we want to make sure that it's not going to jeopardize or compromise their eligibility or a disruption of their benefits. So what happens if you have a child that has special needs, and you're making all of these, medical financial decisions for your child because you are the, guardian, the parents, when that child now turns 18 and becomes an adult. So you need to start planning in advance for that event. If you think that the child would not have capacity by virtue of the disability, even as an adult at 18, we want to start thinking about that a few years in advance. So we usually say around age 16, you may want to start thinking about commencing a court proceeding, which would be a guardianship proceeding. There are two possible routes that you can explore. One is through surrogate's court through an Article 17 proceeding, or Supreme Court through an Article 81 proceeding. And that would be where the parents or someone else is appointed the legal guardian of the child Once the child reaches the age of majority in New York, which is age 18, and becomes an adult. So again, then the parents can automatically continue to make educational, medical decisions, financial decisions for the child with no interruption or delay. Once the special needs child attains the age of majority and becomes an adult and attains the age of 18, then we need to consider, is that child competent to sign any type of advance directives? That would be a power of attorney for financial decisions, a healthcare proxy for medical decisions, a HIPAA release to allow for the disclosure of healthcare and testing medical information, maybe even a living will, which is a do not resuscitate, or any of those types of documents. So again, so that the parent or the person involved in the special needs person's life can continue to help in making decisions, or can take over to make a decision if that person later on does become incapacitated. It's also a good time to think about eligibility for government benefits. So oftentimes with SSI, the child is not eligible when he or she is a minor, because there is deeming, which means the parent's assets are considered in approving the child's benefit. When the child turns 18 and is basically emancipated, the parent's parental deeming will stop, and then the child will qualify from a financial perspective on their own. And so that's often when SSI will kick in, if that person will not be able to be gainfully employed. You'll also, as the parents or the person involved in the special needs person's life, want to evaluate your estate planning documents. Do you have a will in place? Does that will leave a special or a supplemental needs trust for that beneficiary share if need be? You may want to think about the creation of a third party supplemental needs trust. And then we also need to consider housing options for an adult special needs person. Will the person be able to live independently? Do you have a family member that you're going to leave in charge if something happens to you, that will take over the care and custody of that person? Are there, support services so that the person can live independently with support? A group residence, there are oftentimes, wait lists. So, you need to plan in advance, do your due diligence, tour some facilities, and really try to map out, the best plan if something were to happen to you, so that you're making an informed decision well in advance and not really strapped for time in that instance. So on your screen, you have some important resources that we've just compiled for you. There is a Council of Parent Advocates and Attorneys. So there's the website. We have a lot of YouTube videos on estate planning for children with special needs. We have the link to our three-part series on that topic. And also a good resource for you is OPWDD, if you're not familiar with that. And that direct link will also have supportive housing resources for you. So creating a financial and legal plan for your loved one, in summary, is comprised of doing planning in advance, whether that would be through a third party supplemental needs trust, if you're the one creating that plan for your loved one and you want to shelter your assets and try, not to disqualify them from any government benefits and not disrupt their current situation in any way. Or is your loved one receiving a personal injury or a lawsuit settlement? Are they receiving an inheritance directly? Did someone make a major gift to them, where we need to consider now what the, circumstances surrounding that or the ramifications of that could be, and protecting and preserving their assets so there's no disruption of benefits. The role of special needs trusts in protecting benefits, choosing the correct trustee to manage that person, the assets in their trust, and having them be knowledgeable in the different areas and cross areas of law, preparing for any supportive services that that person may need, housing, and preparing for future care and ensuring long-term security. So, what makes us at Russo Law Group different? Well, we have been practicing elder law, special needs, and estate planning since 1985. So, our experience is your protection. We don't just dabble in this area of practice, we are fully committed to always being on top of ever changing law. And this year, we're actually celebrating our 40-year anniversary. We are six partners here at the law firm. We have four associates and over 20 case managers and support staff. We were ranked as the best law firm in the area of elder law by Best Lawyers. We do have three convenient offices in Garden City, Lido Beach, and Islandia, and we've served over 17,000 families. These are all of our, again, areas of practice: estate planning, elder law, special needs, disability planning, guardianship, trust and estates, Medicaid, small business and succession planning, and we also handle real estate. Okay, so it looks like we are at our question and answer segment. So I'm just going to pull that up and see if we have any questions that I can answer for you today. Okay, I'll give it a couple minutes. It looks like there's nothing that has come in so far. Okay, so I have someone that did ask, can you talk about the 3-year look back? I just lost it. Hold on one second. Can you talk about the 3-year look back when planning for kids at age 16? Yes. So in order to qualify for SSI, there is a 3-year look back period. And so again, you need to plan in advance, and not wait until the last minute to try to apply for any type of benefit. But if any assets were transferred, it's similar to, a Medicaid look back period, in that the assets are evaluated. There needs to be disclosure, and if there were any transfers, that may be causing a period of ineligibility. Okay, we have another question that came in. What type of estate would best serve if my wife has a terminal disease? So I think what you're referring to is what type of an estate plan would work best. So every case is different, and so we view each case on, a very tailored basis. But if anyone, a loved one, gets diagnosed with a terminal illness, then we want to take a look at that person's estate plan. We want disclosure of, that person's financials. We want to know if they have named beneficiaries on assets, and we need to speak to that person and decipher how they want to leave their assets when they pass. And so when you get diagnosed with a terminal illness, I think, that's when that discussion really hits home. And we need to be able to act before that person, were to lose any type of incapacity. But it can be through a will, or it can be through a trust, or it can be in a combination of both. So there's no real, definitive answer to that. It's all really case specific. So I would encourage you, to schedule an appointment, and we can definitely handle that for you. And there is a coupon that is available to any of the attendees. So we are offering a coupon with a $200 rebate on any consultation that you schedule by virtue of being an attendee at this seminar. So we normally would charge $600 for a 90-minute consultation, but there is a limited offer for any attendees, and that would be at a $200 discount, so that the consultation would be 400, and there is an expiration of April 26, 2025, to use that coupon code. Okay. So I believe I answered all of the questions. You can also feel free to email me if there's something, a question that I didn't get to answer, or you didn't get to post, or is more personal. My email is D as in Diana, Latanzio, Lattanzio at vjrussolaw.com. There is no, so someone asked about the coupon code. There is no specific code. You just mentioned that you were an attendee, and it looks like it will be emailed tomorrow to the attendees. Okay. Thank you so much for joining my seminar today, and I hope everyone has a great day.